Good evening, this is Laws 12067 Environmental Law, and tonight we're in Term 3, 2015, but we're dealing with a general issue involving strategic environmental planning and assessment. We have a special guest, Andrew Magoffin, Town Planner, who is a student in the course, is going to address us in relation to some of the intricacies involving town planning issues. Andrew is a town planner, having completed his degree at the University of Queensland and has been working in that capacity for over 10 years. So Andrew, a warm welcome to you. Thank you very much for addressing us tonight, and if I can hand it over to you now. Thank you.
No problems. Thank you, John. I just wanted to obviously speak about IDAS, the Integrated Development Assessment System, which is under the Sustainable Planning Act. But before I do that, I'd like to speak generally about environmental law from my perspective, which is very much the perspective of someone who practices as a town planner and is exposed to matters relating to environmental law, if you like. I'm going to run through environmental law from the basis of the who, the what, the when, the why, the where and the how. I might miss one or two of those that aren't so significant, but you get the gist of what I'm suggesting. So I'll start with the who in environmental law. Well, it's the source of environmental law is the Commonwealth government. It's so it's the legislature, but at all levels of government: Commonwealth, the state, and the local. Just touching on the Commonwealth, which is the main topic of this particular course, I understand the Commonwealth legislation in relation to environmental law is the Environmental Protection and Biodiversity Conservation Act. The powers afforded to the federal government in relation to legislating for matters related to the environment are bestowed upon them by the Constitution, Section 51. So the Commonwealth has jurisdiction and an ability to legislate for the environment, and they've done so. They've taken that opportunity, and that's the EPBC Act. What it covers, that particular act covers matters of national environmental significance. So that's actually the phraseology used in the legislation itself. I made a post on UCrew recently about a particular project up near the Great Barrier Reef somewhere. And that post included links to material that was of relevance, namely what I would do as a consulting town planner is if I was approached by a developer with a property that was bordering the Great Barrier Reef, for example, it would immediately raise alarm bells to me that, hey, there might be some requirements in respect of the tool there that's called a protected matters search tool. So it's on their website, the Department of Environment, that is. You can go to that tool, enter in your property. It typically requires a lot description. And then you can reveal what matters of national environmental significance are relevant to that particular property. And if you then refer to the EPBC Act, you can ascertain whether approval is required from the federal authority under that act, and that depends on the nature and scale of what's proposed to be done with the land. So at a federal level, you've got this EPBC Act. You can do some searches through the Department of Environment's website to ascertain whether the property that's of interest to you is triggered for assessment against that act based on knowing what is proposed to be done with the given parcel of land. So that's the source of law for the environment at the federal level. If I move on to the state, well, the state is also a source of environmental law, the Queensland government. The principal statutes under the Queensland system the Sustainable Planning Act, which is obviously referenced throughout this course, and in particular, I think the lecture notes for week 6. So the Sustainable Planning Act is effectively a statute to regulate development, and the Act itself defines what development is, Certainly most people in the community would have a general understanding of the word development, but naturally it needs to be defined in the legislation, and it certainly is. So what constitutes development, and the ones that I would typically deal with on a day in, day out basis as a consulting town planner are material change of use, and that is one of a number of things. For example, the commencement of a new use of a premises, the increase in intensity or scale of an existing use, or the recommencement of a use that was once operating and is now proposed to be recommenced. So there's a number of things that material change of use encapsulates. That is a form of development that I deal with on a daily basis. Think of a developer in and around Brisbane who purchases a property for the purposes of building an apartment project. So building an apartment building. Perhaps he needs to demolish 2 existing houses and then proposes a 15-storey apartment building. That is a material change of use. The use of the premises here and now is detached dwelling or dwelling house, in fact 2 of them, in that example at least. And what he's proposing to do is commence a new use, and the new use namely is apartments, or however it's defined under the relevant planning scheme, and I'll get to planning schemes soon enough. So SPA regulates development. Development includes material change of use. Development also includes reconfiguration of a lot. What that is subdivision, effectively. So if I was proposing to subdivide the lot that I call home, the property that I own, it's a development for the purposes of SPA. Subdividing land is reconfiguring a lot. So that's one form of development under SPA. Operational works is another form of development under SPA. It's not one that I deal with as frequently as material change of use and reconfiguration of a lot, but operational works is a form of development under SPA. It includes things such as earthworks. So if for that apartment project that I used as an example, if the developer is proposing basement car parking, then naturally there will be some excavation works undertaken to accommodate the basement car park effectively. So the excavation works, being earthworks, is actually a form of development itself. It's called operational works. Various councils refer to it in different ways. Gold Coast calls it change to ground level. Brisbane calls it filling and excavation. But whatever the local words used, effectively it's development for the purposes of SPA. It's called operational works. So as I said, the state government is a source of environmental law here in Queensland and other states naturally. SPA is the chief statute for regulating development, and I'll come back to SPA later because it's important. That is the legislation in which IDAS is embedded. The other key statute for Queensland in an environmental law sense is the Environmental Protection Act. It regulates development too. At least it regulates development that's defined as environmentally relevant activities. So think of a mine, for example, or a quarry, or even many years ago, and they've removed it now, a motor mechanic. A motor mechanic's workshop was defined as an environmentally relevant activity because of the potential for it to generate pollutants that could flow through into the stormwater system and eventually out to the waterways, etc., etc. So it's no longer, by the way, it's no longer defined as an environmentally relevant activity, but certainly mining is, and a quarry is, for example, and there's a whole host of other things, chemical, manufacturing. If you went to the EPA Act, the EPA, you would find a list of activities that are defined as environmentally relevant activities. So the Environmental Protection Act of Queensland regulates development too, as does SPA, but it regulates development relating to, or development that's defined as an environmentally relevant activity. But the EPA also has another function. It establishes a framework for enforcement. So think of a situation whereby a person is using their premises for a particular use, and assuming that use is lawful. Think of the scenario whereby pollutants are escaping from the premises because there is no adequate measures adopted to prevent that from occurring. Well, the Environmental Protection Act of Queensland affords local government authorities the power to seek to rectify that environmental nuisance, or even an environmental offence, if you like. So the EPA regulates development, but it also establishes a framework for enforcement in the event that things are being done with a given property that are beyond what is permissible. Also in the EPA, recent example for me is that I've got a client who owns a property in Lytton, which is an eastern suburb of Brisbane. The local government authority, being Brisbane City Council, issued a show cause notice to them under the Environmental Protection Act. Show cause notice was for the emission of noise from the property beyond the limits that are prescribed in that particular act. As it turned out, well, we knew at the stage anyway, the developer was using the premises for unlawfully, because he had not obtained an approval for the use of the premises, when in fact an approval was required before he went and put that premises to that particular use. But putting that aside, the local government authority issued him a show cause notice saying, demonstrate or show cause as to why we shouldn't prosecute you for emission of noise emanating from your property, given the way that the property is being used, and it's causing a noise nuisance to nearby residents that is beyond the limits that are deemed tolerable under that particular act. So that's an example of the Act, the Environmental Protection Act, affording local government authorities a power to take enforcement action when the situation calls for it. So that's the state realm in respect of environmental law, at least the two primary statutes, SPA and the Environmental Protection Act. So I'll come back to SPA later. A further source of environmental law is at the local government level. And this, by far and away, is the level that I deal with on a daily basis, much more than the Commonwealth and the state level. In actual fact, very rarely have I had to even look at the Environmental Protection and Biodiversity Conservation Act, which is the Commonwealth legislation. Sure, that's probably affected by the fact that I practice predominantly in Brisbane, as opposed to having an office or operating from an office that is, say, near the Great Barrier Reef. But yeah, by far and away, the vast majority of my experience with environmental law is environmental law that is the source of a local level, or the source of environmental law at the local level is where I tend to operate, and most consulting town planners will. So I know a lot about the local level in respect of environmental law. Think of local planning instruments, and the Sustainable Planning Act identifies what is a local planning instrument. It also identifies what is a state planning instrument, but here and now we're talking about local planning instruments. A local planning instrument, and this is something that most of you will be familiar with, I assume, is a planning scheme. So Brisbane City Council has a planning scheme, Gold Coast City Council has a planning scheme, Moreton Bay, you name it. Any local government, every local government authority in Queensland, as far as I'm aware, has a planning scheme that regulates development in their particular local government area. So planning scheme is the bread and butter of a consulting town planner. When a developer comes to me and asks what might be achievable on a given parcel of land, 99 times out of 100, the first port of call is the planning scheme. Certainly, if you pull up a property and you become aware immediately that it's sitting in the middle of the Great Barrier Reef or something like that, then sure, you're going to need to have regard to the EPBC Act. But by far and away, the majority of my experience is at that local level. So planning schemes. A planning scheme isn't legislation as such, but it has a similar statutory effect. It's the statutory effect of a planning scheme and other local planning instruments is afforded by the Statutory Instruments Act of Queensland. This is something I only found out today. I've often thought about it, but I've never had to put my finger on it. But so the sources of environmental law that I've spoken about before getting to the local level are certainly statutes. There's certainly legislation. But when you get to the local level, a planning scheme, for example, its statutory effect is afforded by this Statutory Instruments Act. So it's not legislation as such, but it is a source of environmental law. I suppose the other thing to mention in talking about the sources of environmental law is, of course, the common law. So the Planning and Environment Court and the Land Court in the case of Queensland. Also tribunals, the Building and Development Tribunal. It's changed its name recently. I can't remember exactly what it's called, but there's a specific tribunal that hears certain matters pertaining to assessment of development. So they're also, of course, sources of environmental law, as is the case when you're studying tax law. The court will, of course, hand down judgments, and that's common law. So the same is the case with environmental law. The court in question in Queensland is the Planning and Environment Court, and also the Land Court. I just point out at this point, the Planning and Environment Court obviously hears matters of planning law, but it also hears matters of environmental law. Think of planning law as assessment of development, assessment of a development application, and for whatever reason, let's assume the local government authority refuses that development application. The developer isn't content with that refusal. The developer feels as though he has rights to an approval, but the council hasn't obliged. The legal recourse for that developer is the Planning and Environment Court. And what he would do is engage a solicitor to lodge an appeal in the P&E Court, appealing from the council's refusal of his development application. And the rest, and I understand there's a guest speaker next week, so I won't go any further into the P&E Court and appeals, but that's all you need to know at this point in time, I think. So that's the sources of environmental law. So that's the who, if you like. I go on to the what. It's all about identified environmental values. So matters of national environmental significance are covered by the Environmental Protection and Biodiversity Conservation Act, which is the Commonwealth source of environmental law. Matters of state environmental significance, and indeed that particular phraseology is used in the state level. So that's obviously something that is encapsulated within environmental law. This is the what of environmental law. We're talking about identified environmental values. Well, who's identified them? Well, we've talked about who, but what are they? Well, at a federal level and a state level and a local level, there is mapping freely available to each and any person that's got an interest in it. There's mapping freely available to assist you in determining whether something on your property is of environmental significance, whether it's of national, state, or local environmental significance. So that's what we're talking about in environmental law, is identified environmental values. A lot of people, I suppose, would think of environmental law and they would think rainforests. They would think the Great Barrier Reef, the dolphins, the koalas, the dugong in Moreton Bay, the coral reef, koalas, I think I mentioned them. These are all the flagships, I suppose, of environmental law. People get emotional about koalas, and rightfully so in my mind. I'm an animal lover. So, but what the average layperson probably doesn't recognise is that environmental law certainly has a role to play in urban environments, heavily urbanised environments. There is still a role for environmental law, and what you'll find is it's typically the role of local environmental law, so through a planning scheme. You'll find even in close proximity to the city here in Brisbane that there's properties that are mapped as being partly within a waterway corridor, properties that are mapped as having locally significant vegetation that council has identified as vegetation to be retained at all costs almost. So when you think of environmental law, I think the average person needs to broaden their horizon and understand that it applies, it has a role to play in heavily urbanised environments as much as it does in those flagships that I spoke of, the Great Barrier Reef, the koalas, the dugong, etc. So, so environmental law is pretty broad. It has a broad coverage. So moving on to the when of environmental law, as I call it, environmental law has a role to play most prominently when development is being proposed. And I've touched on development. I spoke earlier about material change of use, about ROL, which is subdivision or reconfiguring a lot, operational works, namely, for example, earthworks, those forms of development. That's when environmental law has its role, interjects itself, I suppose, or for want of a better phrase. So environmental law has a role to play when development is proposed. Now, not every development will require me as a consulting town planner to delve into the Commonwealth legislation. It won't require me in every instance to look at the state legislation, but every development will require me to at least look at the planning scheme because that is more often than not the primary planning instrument that dictates what can and can't be done with a given property. So environmental law has a role to play when development is proposed, but it also has a role to play in ensuring that a developer and or a landowner sticks to obligations that are enforced upon them through conditions of a development approval. So there's an ongoing role for environmental law. So if I was to obtain a development approval for a client of mine, it would be 30 pages long, no word of a lie. That's the way it is these days. And there'll be tens, in some cases, hundreds of conditions of approval. Some of those conditions will require the developer to do certain things before the new use, for example, commences. So before he builds his apartment building or before he subdivides the land, he might be required to do such things as ensure the retention of some trees that have been identified on his site as being of local significance or even state significance. So a developer will have obligations in enacting his development approval, but there will also be obligations in some instances that are ongoing and enduring, if you like. Ones that, for example, a covenant, if a covenant is placed over a property, an environmental covenant, for example, then that covenant might well require of the landowner that nothing happens in a particular portion of that site other than actions that are consistent with maintenance of the environmental values of that particular portion of the site. So that's just an example. So that's the when of environmental law. It has a role to play when development is proposed, but it has an enduring role as well in land management, I suppose. Where of environmental law, I've said, look, areas mapped as being of environmental significance, whether that's at the federal level, or the state level, or the local level. The 9 times out of 10, environmental law will have some role to play. And what you need to do, and certainly what I do as a consulting town planner, is once I'm given the property details of my client's land holding, or the one that he or she is interested in acquiring, for example, then I go and conduct various searches. I search, first port of call, as I said before, usually 99 times out of 100 is the local level. I will go to the planning scheme, search the interactive mapping, identify what the zoning is of the property, identify if there's a neighbourhood plan that applies to the property, identify if there's some overlays. An overlay could be the airport overlay, so it could be waterway corridors, it could be all sorts of things are mapped on overlays. And the results of that property search tell me what, give me an indication of what's likely to be achievable from that given parcel of land. Certainly a zone will provide some statements in the planning scheme, some zoning statements that indicate what that particular parcel of land is intended to accommodate, what type of development, at what scale is that development intended to be accommodated in that locality. So in talking about the where of environmental law, I go to the mapping sources, the sources of mapping in relation to environmental significance. But also, if land next door to the property that we're looking at is mapped as environmentally significant at Commonwealth or state or local level, it still has, or has the potential to have, implications for the particular property that I'm looking into on behalf of my client. So you really need to be aware of these mapping tools that are available to you, and that's the where, I suppose. So talking about the why of environmental law, and a lot of this is mentioned in John's material throughout the course. Intergenerational equality. It's not a new concept. Everyone's aware of that concept these days. We need to protect the environment such that generations that are to follow us aren't disadvantaged by the legacy that we've left behind. So this intergenerational equality concept, or that's the reason for being, I suppose, when we're talking about environmental law. And within that, or at least coupling with that, is ecological sustainability. Ecological sustainability is mentioned as the purpose of the Environmental Protection Act of Queensland, for example. You'll find ecological sustainability referenced in the purpose statement, possibly, I haven't read it for a while, of the Sustainable Planning Act, or it certainly will be there or thereabouts. Ecological sustainability, we talk about the triple bottom line. We're talking about economic, social, environmental. This course is environmental law, and so naturally we're focusing on the environment, but ecological sustainability isn't just about protecting the environment at all costs. There is a crossing of paths, if you like, and where those paths cross and how and at what time depends in any given circumstance. But there are a crossing of paths of the economic, of the social, of the environmental. Often there's tension between all of those particular strands of what we call the triple bottom line. So thinking about the why of environmental law, think about ecological sustainability, but don't just think about environmental only. The triple bottom line is economic, social, and environmental. So yeah, I'd encourage you to read the purpose statements of those statutes that I referenced before. A lot of them will reference ecological sustainability as the purpose of the legislation itself. So that's the why. The how of environmental law. well, regulation, development regulation and enforcement. So if in the developer's example, a developer comes to me with a parcel of land, he wants to do X, Y, Z with it. If I determine by reference to the planning scheme, and I'll get to this soon, if I determine by reference to the planning scheme that he needs a development approval before he can lawfully commence that particular use or that particular development, then that's what we go about doing. I advise on the costs and the timeframes and the prospects of success, etc., etc. But that is the regular component of what is environmental law. Enforcement is something that I mentioned earlier under the Environmental Protection Act of Queensland. If a local government authority, for example, has reason to believe that an environmental offence is occurring on a property, then they can seek to remedy that situation. And what will happen is the landowner and or the occupant of the site will receive a show cause notice. It'll be show cause as to why we shouldn't prosecute you. We reasonably believe you're doing X, Y, Z on this property, when that is clearly in contravention of the Environmental Protection Act, for example, is one example. And then, obviously the developer has to respond to that. Well, it's in their best interest to respond to that. And then if the response isn't adequate, namely if they don't take action to remedy the council's concerns, assuming the council's concerns are lawful, are solid in terms of a legal sense, then council can proceed to an enforcement notice. And then effectively, if they don't respond to that appropriately, the council's taking them to court. So that's the enforcement side of environmental law. So there's this regulation side and there's this enforcement side. Regulation applies to development assessment when you're going and seeking approval to develop land, and the enforcement side applies to land management, I suppose, independent of development assessment. So so that's environmental law through my eyes as a consulting town planner. As I said, the vast majority of my time, day in, day out, is at that local level. What does the planning scheme say about what this client's proposing to do with this land? Very rarely do I get to that Commonwealth level of actually having to look at the Environmental Protection and Biodiversity Conservation Act. One thing I'll say also is once a planning scheme for a local government authority has been prepared and gone through some state interest checks, so it goes through some state interest checks before it actually commences. So I'll use Brisbane as an example. A planning scheme was released in June of last year, Brisbane City Plan 2014. Before it commenced on the 30th of June last year, it was years in the drafting. And it went through 2 state interest checks as a minimum. And the state interest checks are legislated for. They're mandated in the Sustainable Planning Act. When council goes through the process of creating a new planning scheme, it must send a draft of that planning scheme to the state government. The state government then reviews that planning scheme for its performance in respect of appropriately dealing with matters of state environmental significance. What we've got here in Brisbane, accordingly, is a planning scheme that has been ticked off by the state as satisfying their requirements within their own relative jurisdiction, that is. So I know that when I am looking at a development proposal here in Brisbane, I know that my first port of call is the planning scheme, and I won't need to look at the state planning policy, which is a state planning instrument under SPA. SPA lists what are state planning instruments. But because Brisbane's adopted a new planning scheme recently, and because recently the state government said, yes, that meets what we require of you in regulating for matters of a state, or actually what it is state government ticking off that the planning scheme appropriately reflects the state planning policy. So I know when I look at development proposals here in Brisbane, I don't need to look at the state planning policy because the planning scheme has been drafted to appropriately reflect those requirements. The same is not true if I was to go out to some of those, no, you don't have to go out far. If I was to go out to some of those Western Queensland local government authorities, because they're typically undermanned, under-resourced, it can take a long time for them to produce a new planning scheme. And so what you get is a lot of lag between a planning scheme. Yeah, for example, some planning schemes in some of those regional areas are the best part of 20 years old now. So naturally, they don't reflect the most recent state planning policy. And the most recent state planning policy is only a couple of years old, mind you. It replaced several state planning policies that were independent. It's all been rolled into one now. But so I know that if a client brings me a parcel of land out at Chinchilla, for example, and if I read the planning scheme and note that it's a 20-year-old document, I know that I need to do my checks at a state level because this planning scheme hasn't been ticked off as one that appropriately reflects the state instruments, okay? So that's very much a practical explanation of that situation. So knowing the status of the local government authority's planning scheme and whether it's been ticked off by state recently as appropriately reflecting their requirements is important, because it means that you either do or you do not need to look at the state planning instruments, or at least the state planning policy, which is a state planning instrument. Okay, we're getting there, and IDAS is where I'll finish. But before I get to IDAS, the last thing I'll mention before IDAS, the lecture notes in week 6 talk about levels of assessment. These levels of assessment are under SPA, the Sustainable Planning Act. There's exempt development, there's self-assessable development, there's code assessable development, there's impact assessable development, there's soon to be, or there at least was soon to be, prohibited development, which 20 years ago did exist, but it was abolished. Nothing here and now is prohibited in Queensland. It's a performance-based planning system, put it that way. If you can demonstrate that a nuclear power plant is appropriate for the middle of the suburbs here in Brisbane, well, you're a genius, for one, but secondly, that it's not likely to happen. But the point I'm making is it's a performance-based planning system, nothing's prohibited. So the levels of assessment under SPA: exempt, self-assessable, code assessable, impact assessable. Day in, day out, where I act as a consulting town planner is code assessable and impact assessable development, because they are the levels of assessment that oblige a developer to seek a development permit from council before he can lawfully go about putting a given property to the use that he's intending for it. Okay, so code assessable and impact assessable development is development for which an approval is required. Code assessable development is the minimum level for being obliged to lodge a DA. And I'll talk about IDAS after, but IDAS has a different effect, or some parts of the IDAS system don't apply to code assessable development, whereas all parts will apply to impact assessable development. Impact assessable development is the highest level of assessment for development in Queensland. I'm sure many of you walking down the street in your neighbourhood at any given time have come across a sign that's been placed on a property's fence or on the site frontage, for example. And it's a big sign. It'll say, proposed development, have your say. And it'll list what is proposed to be done with that property, who the applicant is, what the property is described as in terms of a lot description, blah, blah, blah. Contact details of council if you want to make a submission. Now, those signs that you come across are signs that are mounted on behalf of the developer because the development that he's proposing on that land is impact assessable development. It's because Chapter 6, Division 5, Part 4 of SPA applies, the notification stage. That is, the development that is impact assessable is development that must be notified to the public. And in notifying it to the public are afforded the right to make a submission to the assessing authority, typically the local government authority like the council. The public are afforded a right to make a submission during that notification period. The notification period is usually 15 business days. And if I was to make a properly made submission during that notification stage, I am then afforded a right of appeal in the Planning and Environment Court in the event that the council goes ahead and approves the development despite me kicking up a stink about it. And I've decided that I'm going to take this to court. I'm not happy with the fact that council's approved a unit block next door to me. I'm going to exercise my right of appeal in the Planning and Environment Court. That situation, that right of appeal afforded to third-party submitters, only applies to impact accessible development. Okay, so impact accessible development is a development type and or scale that requires the developer to seek a development permit from council, and in relation to IDAS, the Integrated Development Assessment System, it obliges him to notify the public in accordance with Chapter 6, Division 5, Part 4. Code accessible, as I said as well, also is a development of a nature and or scale that requires prior approval from council before it can lawfully commence, but it is development that doesn't require public notification. And I will come to each of those stages of IDAS soon, very soon. The last two things I'll mention, self-assessable development is development that doesn't require the consent of the local government authority before it can lawfully commence, but it's conditional. The condition is this: development that is listed as self-assessable, and by the way, where you go to determine whether a development is self-assessable or code or impact is the planning scheme. You go and look at the zoning that your property is identified in, and go look at the zone, and the zone will have some tables of assessment, and you've got to determine what the nature is of the proposed development, and then you've got to determine whether it's listed as self-assessable, code accessible, or impact accessible, or exempt even. So the self-assessable development is development that doesn't require lodgement of a DA to council, provided it complies with all relevant acceptable outcomes, and that's planning jargon, really. It's in the planning schemes. Provided the development complies with all relevant acceptable outcomes from the planning scheme, then in that instance you don't need to seek an approval from council. But on the other side of the coin, if a developer comes to me and says, I want to do this with a property, I go to the planning scheme, determine that it's listed as self-assessable, and then identify for him all the relevant acceptable outcomes that he needs to comply with. If he then says, I can't comply with that one, or I don't want to have to comply with that one, as soon as that happens, the development is then a development that requires consent from the local government authority. It effectively bumps up to code accessible development. So you'll find, to put a little practical spin on it, think of a vacant block of land in Brisbane. I keep mentioning Brisbane, obviously I live in Brisbane. Think of a vacant block of land in Brisbane. It's surrounded by houses. Any layperson will come along, walk along the street and go, oh, I can build a house there. There's a house next door to it that's built on the land. There's a house next door to that one on the other block of land. I'm going to go in there and build my house. You can almost rest assured that that development will be self-assessable, because the zoning is intended to accommodate a single house on one single block of land. That covers the vast majority of the suburbs in any given city, to be honest. So dwelling houses, one single dwelling house on one block of land, 999 times out of 1,000 will be self-assessable development. So you don't need to go and get your DA from council. You'll need a building approval, and that's regulated under the building the Building Act of Queensland, 1975, I think. But you don't need a development approval. There's a distinction between development approvals under SPA and building approvals under the Building Act. So, yes, you'll need your building approval before AV Jennings goes and puts up the frame and et cetera, but you won't need a development approval, at least not typically. So that's self-assessable development. It's conditional. It is no development approval required, conditional upon you complying with these things that councils identified in their planning scheme as being applicable to self-assessable development of that type and that scale. Exempt development very rarely happens. And when a developer comes to me and says, I've got a block of land, I want to do this with it, I don't think in 11 years it's turned out to be exempt development. That's because there are a number of things. Developers tend to want to put the highest and best use of the land. They want to develop the land for its highest and best use. Naturally, a given parcel of land, the highest and best use of a given parcel of land is typically something that council will want to review before that particular development can go ahead. So exempt development is pretty rare, but there are things that are exempt depending on what zoning your property is located in and what you're intending to do with it. So those are the levels of assessment under SPA. Exempt means away you go, knock yourself out, do what you want. Self-assessable means you don't need to lodge a DA to council, provided you comply with these things that are identified in the planning scheme. Code assessable and impact assessable, you have to go and get your DA from council. If you don't, and you go and do that particular development without it, then expect that you'd be issued with a show cause notice. Show cause as to why we shouldn't prosecute you. You're committing a development offence by virtue of the fact of putting a parcel of land to a given use when the zoning dictates that that given use is one which requires prior development approval. Those are the levels of assessment. Now, they are relevant to IDAS, and that's where I'll finish. IDAS is it's the bread and butter of a consulting town planner. That is, you need to know as a consulting town planner the process through which a development application will be assessed, and that is IDAS. IDAS has an application stage, it has an information and referral stage, it has a notification stage, again that only applies to impact assessable, remember. It has a decision stage. So think about, I'll talk about it in a practical sense. A developer comes to me, given parcel of land, wants to build an apartment building. We say it's code assessable. He says, fine, go ahead. We engage the architects. They produce plans that the client's happy with in terms of yield, in terms of appearance of the development, you know, design itself, et cetera, et cetera. And of course, as guided by what the planning scheme indicates is appropriate for that locality in terms of building height, in terms of setbacks to boundaries, et cetera, et cetera. We go and prepare that development application for the developer. We then lodge it to council. That's the application stage, and it only ends when council gives you an acknowledgement of lodgement of your application. Okay, so we lodge an application to council, we pay the fee, we fill in the right forms, and there's forms that you have to fill in. You have to address compliance with the planning scheme. There's certain mandatory requirements of a development application. Assuming we tick all those mandatory requirements, we tick those boxes, then council will give us an acknowledgement notice, and that has to occur within 10 business days of lodging the development application. The acknowledgement notice is, the requirements of the acknowledgement notice are set out in SPA, Chapter 6, Division 5, Part 2. It says an acknowledgement notice must contain this, blah, blah, blah. Effectively, all it is a piece of paperwork. It's a paper trail. We acknowledge receipt of your application on X date on behalf of X, seeking approval for Y. Here's your acknowledgement of the application having been lodged. Once that's occurred, once the applicant is in receipt of that acknowledgement notice, the application stage is over. You then move into information and referral stage. That's Chapter 6, Division 5, Part 3 of SPA. Information and referral stage is simply this. well, it has two elements, as the name would suggest. Referral. Okay. If the acknowledgement notice that you've received from council says that the development triggers referral to the state government for the fact, as an example, for the fact that the property fronts a state-controlled road, then in the information and referral stage, the applicant in the development application is obliged to refer the development application to the Department of Transport and Main Roads, or whatever department is the one that's the authority for the referral trigger. Referral triggers outlined in Schedule 7 of the Sustainable Planning Regulation. So that's delegated legislation under SPA. Schedule 7 outlines instances where applications need to be referred to state government. Okay, so we've got our acknowledgement notice. Let's say it says you've got to refer to the state government because your property fronts the state-controlled road. Well, that's what we go and do. And you've got a certain statutory time frame in which to do that. I think you've got 20 business days to properly refer your development application to the state government. The vast majority of DAs, to be honest, don't require state referral. So you'll get an acknowledgement that says this needn't be referred. And so in that instance, the information and referral stage is merely, for all intents and purposes, an information stage. And what that is it affords council or the assessing authority, whoever that might be, it's typically councils, it affords council the ability to make a request for further information of the applicant. So they'll go, okay, we've assessed the material that you submitted with this DA. We have questions about this, or we don't like that, or please address this particular overlay. You haven't addressed that. Or these trees on this site are protected trees at a local level. You're proposing to bulldoze them. Please, provide additional justification why we should support that. So this is the information and referral stage. Almost every development application I've lodged has attracted an information request. It's just the way it is. So council always has questions of what it is you're proposing to do. Questions, justify this or provide additional detail here and there. Okay, so that stage ends when the applicant has responded to that information request. So the information request that council gives you, they've got 10 business days to give you an information request after the end of the application stage. But they can choose to extend that period. They've got an as of right extension to that period, and that as of right extension is for another 10 business days. So worst case scenario, in 20 business days after you got the acknowledgement notice, you should be in receipt of an information request from council. You've got 6 months to respond to that. 6 calendar months to respond to that information request. Naturally, a developer will want you to get it in 6 minutes or 6 days, not 6 months, because time is money. But you do actually have 6 months to respond to an information request. But once you've responded to the information request, and certainly you've got the right to respond in full, respond in part, or not respond at all. But naturally, it's in your best interest to respond to the best of your ability. So we usually respond in full or at least in part. So once you've responded to that information request, you then move on to the next stage in IDAS, which is the notification stage, but only if your development application is impact accessible. So the notification stage for impact accessible developments only is what I alluded to before, or what I discussed before. The statutory requirements of the applicant, that is, publish a notice in the public notices section of newspaper circulating in the general vicinity of the site. You've got to publish a notice in that paper for at least once. So one business day, you've got to run a newspaper ad alerting people of the fact you're proposing impact accessible development in their neighbourhood, effectively. Also, you have to send letters to all the adjoining landowners, those landowners who have a property boundary common to the subject site, that is. So you send letters to all the adjoining landowners saying, hey, this is what X, Y, and Z developments are proposing to do with this given parcel of land. You also have to put up a sign on every street frontage that the subject site has. So if the site has 2 road frontages, you've got to put up a sign on each of the frontages that says, proposed development, have your say, from 2 dwelling houses to a 60-story apartment building, for example. You describe the nature of what it is you're proposing to do. That's set out on in the signage that gets mounted on the subject site's frontage. There's stat guidelines, or there's in the regulation, the sustainable planning regulation, there's it outlines what's required of those particular documents. So the newspaper ad, the letters to adjoining landowners, the signage on the street, for example, that's all set out for us. So there's no freelancing there. You've got to follow the law. So notification stage typically lasts for 15 business days, but with certain development applications, and I won't go into those, it's pretty complex, but with certain development applications, there will be a 30 business day assessment notification period. But the vast majority of notifications are 15 business days only. And effectively what's happening there is you're encouraging, or the developer doesn't want to encourage, but effectively what's being legislated for is affording the right to third parties to make submissions to council on what's proposed to be done with that given parcel of land. So again, notification stage doesn't apply to code accessible development. It only applies to impact accessible development. Once you've notified for your 15 business days, you'd sent the letters to the adjoining landowners, blah, blah, blah. You then send a notice of compliance to council saying, hey, we've complied with the Act with respect to public notification. Here's the notice of compliance. At that point, you then enter decision stage for the development application. Decision stage, as the name would suggest, is the time in which council must decide whether to approve the application or refuse the application. Council has 20 business days to make that decision, but they have a statutory right to extend that initial period for a further 20 business days. They almost always do. And so decision stage in reality is almost always 40 business days. Obviously, if your development type is of a low risk nature, it's a very small type of development, a 1 lot into 2 lot subdivision, for example, well, maybe council can get them out, depending on their resourcing. They might be able to get that out in the initial 20 business day assessment period. But almost all DAs I handle run for the 40 business days in full in respect of that decision stage. So that's IDAS. It really is. It's a part of the Sustainable Planning Act that sets out the process through which a development application will be put through the ringer. That's basically it. Council, of course, in decision stage, they have the right to refuse. They have the right to approve. They have the right to approve with conditions. In the vast majority of my cases, you'll get an approval with conditions. We do get refusals occasionally, but obviously if something's likely to be refused, we won't encourage the developer to incur the expense or the time in lodging a DA. So refusals aren't, they're sort of 1 in 10, maybe 1 in 10 DAs would be refused because council's decided, or council might have a different interpretation of the planning scheme to the interpretation that I have, for example, when I advised the developer at the outset that he could do that. Of course, we never commit to anything. In consulting, you say, you talk about prospects of success being good or whatnot. So, because ultimately it's not you who makes the decision when you're the consulting town planner, it's the local government authority. So you can only speculate as to what their decision is likely to be, but it's more than speculation if you've been in the game for a number of years and you've been privy to decisions of a like nature or development types of a like nature, for example. Okay, so that's IDAS, application stage, information referral stage, notification stage, decision stage. That's it, that's me done.
Andrew, thank you very much. The decisions that you've made reference to from council in relation to various conditions on a DA, are they accessible to the public? for future reference. For example, as lawyers, we're used to working with precedents, and you've made comment that, look, if you've done this long enough, you get a fair idea of what the council are likely to do. Is there something that applies at that executive level that operate as a precedent source?
Yeah, naturally, the experience that we gain from handling development applications on behalf of developers is the experience of ourselves, our own experience, that the DAs that we lodge, we learn from. But it's more than that. If you're not even in the game, if you're a layperson and you're wanting to know what's proposed next door, let's say there is a development proposed next door, but it's not impact accessible, so you're not afforded, they're not publicly notifying it, and you're not afforded a right to appeal, you can still find out what's proposed, because 90%, I would say, of local government authorities in Queensland have a tool on their website which enables you to access this information. What you can do in most cases, or certainly in Brisbane, it's called PD Online, Planning and Development Online. You go to PD Online, you punch in the property details that interest you. So your next door neighbour's block, if you notice they've demolished 2 houses, you're thinking, oh, what's going on here? You go to PD Online, you punch in their property details, 20 Johnson Street or whatever. Ideally, you've got a lot description, so lot 1 on registered plan 2, 3, 4, 5, 6, whatever. But you can search via street address and by real property description. So you go to PD Online, you enter that property details. It will, and it doesn't backdate to 20, 30 years ago, but it will give you access to applications that have been lodged on that property over the last, it varies from local government to local government. But in Brisbane, you can look at DAs that were lodged and approved 10 years ago on a property. It's all there. It's all publicly accessible information. And so certainly, let's say the next door neighbour has lodged a DA, they've lodged it yesterday. Somehow you catch wind of it. You can go to PD Online, you can look at what they've lodged, what they're proposing to do. You can pick holes in it if you know what you're doing. They haven't filled in the forms right. They haven't justified this. They haven't justified that. So, yeah, it's all publicly available information. And naturally, for us as consulting town planners, we like to keep an eye on other consultants' DAs if they are ones that we feel we can learn from. Let's say one of our competitors has. Let's say a client has come to us and said, we want to do this with the land, and we've formed the opinion that it's not likely to be approved. Let's say they go, well, bugger you then, I'm going over to Joe Blogg's Planning Proprietary Limited and I'm going to get them to do it. If the planners form the opinion that it's doable and then they go and lodge that DA, we as competing professionals will keep our eye on that DA and go, okay, well, how is this going to go? We thought it was going to be knocked back. They've lodged it anyway, gone to considerable expense in doing so. Let's keep an eye on it. And certainly there are those situations. I've got my eye on a few DAs that are in that sort of boat. So yeah, all that information is publicly accessible. And yes, you can learn lessons from what your competitors are doing and in advising developers in that context.
Well, I can appreciate that you can learn from what others are doing and what has happened in the past, but to what extent, if at all, can you use that in advancing an argument based on precedent of what has happened in the past, like we do in court cases?
Yep. Precedent is a sketchy area in this field, to be honest. If you've got a development approved next door and it's approved under the current planning scheme and you're proposing basically a mirror image of it, and your application is refused but the one next door was approved, there's certainly in that sort of situation some clout behind you to say that council was wrong in refusing it because they've approved it next door. But precedence doesn't really wash with council. Council will tell you that every given parcel of land is unique, and they're quite right. I mean, the block of land next door to me here, sure, it's very, very similar in a global sense in terms of location, but the landform, what trees are on it, what built improvements are on it, blah blah blah. Every parcel of land is unique, so precedence doesn't really wash, but certainly it has clout in the P&E court, and we certainly do take note of decisions of the P&E court when matters do go there. But when you're trying to justify something to council in the development application stage, precedent is pretty weak, unless you've got a real like-for-like, almost identical situation. Then it's going to have some weight. But yeah, it's not like law in that sense, where a local government authority is not bound by what they decided in a similar instance last year or 2 years ago. They're not bound to make a decision that's similar. So that differs, I suppose, to the legal world.
So how do you go about determining whether the conditions that have been imposed by council are reasonable or excessive?
The Sustainable Planning Act mandates that conditions of approval must be relevant and reasonable. Those are the terms used in the Act. I can't cite the particular section of the Act, but those are the terms: relevant and reasonable. Okay. Relevant and reasonable is what the conditions must be, and it's a subjective thing. What's relevant and reasonable to the local government authority might be wholly irrelevant and wholly unreasonable to the developer. And practically, this is where a lot of matters go to the Planning and Environment Court. They go to the P&E court on the grounds that the council believes something is reasonable to be conditioned in an approval, and the developer begs to differ, and they can't come to terms on that, and council sticks to their guns. The developer decides it's going to be too costly to do, or that's unreasonable for another reason, and he goes, well, I'm going to appeal to the court from council imposing that condition on my approval. So yeah, it's a subjective thing, John. But certainly from experience in the game that things can pop out to you pretty quickly, whether council's trying something on, or whether it just seems unreasonable given what's proposed on the land. If council's saying build a sewer line over in Bracken Ridge, when your property's on the south side of Brisbane, you'll go, well, it's completely irrelevant to my development. It has no impact on that sewer infrastructure. It's that's unreasonable and or irrelevant. So, but more often than not, it's not so clear whether something's irrelevant or unreasonable to condition in an approval, and that certainly is the source of a lot of the court's time, the Planning and Environment Court.
And when a developer is proposing a development, who drives the application? Is it town planners, architects, engineers, or is there some sort of conflict between experts in terms of who's going to be in charge of the process?
More often than not, the consulting town planner will be the lead consultant, but every developer has their preferences. Let's talk about a high rise in the Brisbane CBD. It really is more often than not the architect that is the lead consultant on a project like that. But if you were to compare that to a land subdivision out in the burbs, then an architect won't even be involved. So it's a consulting town planner and a land surveyor ultimately who subdivides the land. They're your lead consultants on a project of that nature. So it really depends on the nature and scale of the proposed development and the developer's preference.
And when do you bring experts in? At an early stage, or only if it looks like there's going to be trouble?
No, it's certainly early. Once I've done a search of a property and ascertained that it's triggered on various overlays, for example, under the planning scheme, I know that in order to address the codes in the planning scheme that relate to those overlays, I need to get some specialist input. So let's say the site in question is mapped on a waterway corridor, or is mapped as being of high ecological significance at the planning scheme level. I can attempt to address the code that corresponds with that overlay in the planning scheme, and you have to address codes. This is your statement as to how the development complies with the planning scheme. I can address that code, but I probably won't be able to address it at a technical level as well as an ecologist would be able to, or an environmental consultant. And so if I feel as though it's likely to be a hotly contested issue, I will get an environmental consultant involved early on and say, this is what's proposed to be done with this property. We're mapped on this overlay. I suspect council will read the Riot Act to us and require strict compliance with the code. We don't want to have to comply with the code, or we can't, or what have you. Can you lend us your professional services in justifying the development despite perhaps being inconsistent with the code under the planning scheme, for example? So it really depends on a case-by-case basis, but usually you get them involved early.
Andrew, I've got to say, you have been very generous with your time, and your discussion tonight has been absolutely excellent. I've been very interested in what you've had to say. I've got more questions, but I won't take any further. But perhaps we could continue some of the discussions through you, crew. And I'm very, very appreciative of your time and your efforts and your expertise. So thank you very much. I appreciate it greatly. We'll upload this session, and I'm sure that many people have gained considerable benefit from watching this presentation. So thank you very much, and all the best. We'll wrap it up now. Thank you very much, Andrew.